Hey everyone, Claudia here. I'm redoing this video because I'm reading through your comments and I'm seeing the discussions on other channels and Reddit forums, and I realized my message needed more clarity. Housing is personal, and when the topic is emotional, it's very easy for viewers to hear something I didn't mean. So today, I'm slowing it down and walking through Bill 60 again in plain language. And let me be crystal clear right now. I do not support anyone who abuses the system on either side. Not tenants who deliberately don't pay and use delays to stay for months, and not the landlords who neglect serious safety issues or mistreat their tenants. There are bad actors on both sides, and the people who are trying to do the things properly are the ones who are getting caught in the crossfire. So what are we talking about? Bill 60 is Ontario's Fighting Delays, Building Faster Act. It's an omnibus bill, meaning it changes multiple laws. The rental piece that has people fired up is Schedule 12, which amends the Residential Tenancies Act and affects processes at the Landlord and Tenant Board. So here's the quick status update. Bill 60 has received royal assent, but the Schedule 12 rental changes come into force on a day that still needs to be proclaimed by the province. So the direction is set, but the timing of when each change becomes active matters. Now, here's where the headlines confuse people. The province floated a proposal about the security of tenure, the protection that lets fixed-term lease automatically roll into a month-to-month. So a tenant can't be told your year is up and you need to leave for no legal reason. After much backlash and protest, the province said it will be moving forward with that consultation, and that part is important. And it's why some people felt relieved, but pulling back on the one idea does not erase the rest of Schedule 12. There's a lot of changes there, and they're still moving forward, and some of them tighten timelines and change what each side can raise at a hearing. And here are the key changes you need to know. First, non-payment notices move faster. Under the amended rules, if a rent is not paid, the landlord can give a notice of termination effective not earlier than the 7th day after the notice is given. So in practical terms, the time to catch up can shrink to roughly 1 week from the 2 weeks that they had before. Second, persistent late payment. That becomes a new eviction pathway, but the definition comes later. Bill 60 adds language about persistent failure to pay rent on the date it becomes due. And it says that counts as persistent will be determined later by regulation. And this is where I understand tenants' concern. If your income is inconsistent, whether it be gig work, variable hours, delayed pay, government assistance timing, these are things beyond your control. You might not be late on purpose, but repeated lateness could still become a problem depending on how persistent is defined and how those rules are applied. And yes, I get how nerve-wracking that is for honest tenants. You can do everything in good faith and still have timing issues beyond your control. You're still paying, but you're paying late, and that pattern could be used against you if persistent is defined in a way that doesn't reflect real life. Third, raising tenant issues during a rent arrears eviction hearing gets harder. Under the amended Section 82, the board must allow a tenant to raise issues that could otherwise be the subject of a tenant application, but only if the tenant meets new requirements. And one of the major requirements is that unless regulations provide otherwise, the tenant must pay half of the rent arrears claimed in the landlord's application before the hearing. The bill also allows regulations to set timelines and, in some circumstances, to require that money be paid into the board instead of directly to the landlord. And why is that controversial? Because tenant groups point to situations where the unit has serious problems, whether it's like mold, pests, broken heat, ongoing leaks, and the tenant has been trying to get repairs resolved, and some of these tenants say they end up paying out of pocket for temporary fixes, cleaning, replacing damaged items, or dealing with the fallout, and that pushes them into arrears. Now, under this change, even if the tenant wants the board to consider those repairs or safety issues in the rent arrears case, they may first need to come up with 50% of the amount claimed before those issues can even be considered at that hearing. And to be fair, landlords say arrear hearings should be about rent, and they're frustrated when unrelated issues get raised last minute and cases drag on. And this is why I keep saying there are bad actors on both sides, and the system needs to stop people from weaponizing delays. The concern is whether a hard payment requirement also blocks tenants with legitimate issues and no cash buffer. Fourth, less time to request a review of an LTB decision. Bill 60 changes the timeline, so a request to review a decision or order must be submitted within 15 days of issuance, unless the board considers it just and appropriate to extend the time. 15 days can be tight if you're working or caring for a family or dealing with a disability, language barrier, or trying to find legal help. Fifth, own use compensation can be removed in some cases. The requirement to compensate a tenant or offer another unit does not apply if the landlord gives at least 120 days notice and the termination date lines up with the end of tenancy period or the end of a fixed term. Tenants are worried because moving costs are huge, first and last month rent, trucks, time off work. Landlords argue they need a workable process when they genuinely require the unit for themselves or an immediate family. 6, increase access to LTB. Decisions and orders, part of the broader direction being debated, alongside measures that can speed up enforcement or eviction orders. Some people see transparency. Tenant advocates worry it can become an informal screaming tool, where being involved in an LTB case, whether you win or you lose, can follow you when you apply for your next home. Now let's talk practical reality. Eviction notices and responding to them. A notice is not the same thing as being evicted that day, but a notice is also not something to ignore. If you receive a notice for non-payment, read it immediately, note the dates and act early. You can pay the arrears, pay as soon as possible, and keep proof. If you can't pay in full, communicate in writing, propose a clear plan, and access supports quickly because of shorter timelines. That means you have less room for delays. If you get an LTB application or a hearing notice, show up and participate. Bring your documents, bring your timeline. If you need help, reach out early to a community legal clinic or a local support program, because last-minute scrambling is where people lose options. Also remember, a landlord still has to apply to the LTB for an eviction order, and the board process has its own steps. This is why the big question is still the backlog. The government has acknowledged that delays and backlogs hurt both tenants and landlords and says it has invested to increase capacity and reduce backlog. Other observers note progress, but most people agree the system is still strained. So changing notice periods and hearing rules may change the pressure points, but it doesn't automatically guarantee fast hearings or fast decisions if the volume of cases are still high. And that's why you're seeing such a strong reaction. Tenants have organized rallies. They've protested against Bill 60, which landlord and industry groups have supported reforms they believe will reduce abuse and speed up decisions. People are arguing from lived experience, so emotions run hot pretty fast. So what's my goal here? It's not to pick a side. It's to lay out what's changing, why it matters, and why people are reacting so strongly. Because the basics are simple. Tenants have an obligation to pay rent, follow the agreement, and landlords have an obligation to maintain the property and keep it safe and habitable. When either side fails that duty, especially intentionally, well, the whole system becomes heavier and more hostile for pretty much everyone else. And I'll say it again because it matters. I don't support abuse of the system on either side. I have to keep saying it because for some reason, people are thinking that I support non-paying tenants in the last video I did. So the most unfortunate part is that honest people can still get caught in the middle. Tenants who genuinely intend to pay but have unpredictable timing, and landlords who genuinely followed the rules but still get dragged in through delays. So to wrap this up, Bill 60 is touchy and controversial because it affects people's homes and financial stability. And I really hope that the government finds a fair balance that protects housing stability while also dealing with genuine abuse and very real delays. But if we're going to be honest, perfect balance is hard because every situation is unique and everyone will feel their justification is the right one. So I want to hear from you guys. Do you think that Bill 60 creates a fair balance between the landlords and tenants? Does it stop bad actors, or does it risk punishing the people who are already trying to do the right thing? Drop your thoughts below, tenant or landlord, and please keep it respectful. Thanks for watching, guys. See you in the next one.